I'm Monica Youn, and I'm a Constitutional Fellow at the Brennan Center for Justice at NYU Law School. Sure. The Brennan Center is a combination of a public interest law firm and a think tank and advocacy institution. And it is mostly lawyers, and we work on kind of fundamental, largely procedural issues of democracy and justice. On the democracy side, our work tends to focus on elections. On the justice side, we tend to work on liberty and national security issues, and also sort of access to justice, the availability of court procedures, and mass incarceration type issues. Well, the center was started by some of Justice Brennan's former clerks with his guidance and kind of blessing. But he made it very clear that he didn't want the center to just continue on, as if we were trying to channel the mind of Justice Brennan at all times. I mean, he knew and he trusted, I guess, the people he was working with to be concerned about the issues of democracy and justice that concerned the justice in his life, but not being kind of slavishly devoted to his memory. I don't think that there's any kind of core statement of Justice Brennan's that the center is trying to organize itself around. I mean, he was someone who sought solutions and saw problems in democracy and in justice, and I think that we try to give ourselves a relatively flexible mandate on those issues as well. Well, I have been, since my time at the Brennan Center, I have been in the democracy program, and I led their campaign finance reform work for some time. And for the past 2 years, I've kind of taken a little bit of a step back, and I've been in this fellowship physically located at NYU Law School, and I've been trying to think a little more deeply about sort of larger constitutional principles involved. Absolutely. I think that when I first started at the Brennan Center, I was much more engaged in the day-to-day battles of what was going on in campaign finance. I started there at 2008. Citizens United was decided in early 2010, and we were engaged in a lot of largely defensive litigation battles on campaign finance. The campaign finance opponents have brought literally hundreds of lawsuits, and we were defending those relatively strategically and also trying to advocate for particular legislation and reforms in Congress and in the states. Yes, so I'm doing quite a bit more theory, and I'm thinking more about what are the core constitutional issues here. If we think that there's something wrong with the vision of the First Amendment as articulated by the majority in Citizens United, then how can we articulate what our sense of the First Amendment is that counteracts that? And so I haven't been nearly as involved in the day-to-day litigation battles and advocacy battles. I mean, I like litigation as something to do. I mean, litigation is kind of the sport of kings. It's a fun thing to do. It's like running marathons. It seems like it's enjoyable, but ultimately it's really bad for you. I'm not sure, however, in terms of overall game plan or strategy, that a primarily litigation strategy makes a lot of sense with the current composition of the court. I think that the court right now is on this kind of deregulatory track in campaign finance, and they keep taking these cases, and we sort of know what they're going to do, and we could just keep throwing ourselves against that wall and expend a lot of research and a lot of resources and a lot of energy, but there are not that many of us on the campaign finance reform advocacy side. We need to be a little strategic about how we're working. So if we are looking forward to a day when the composition of the court or the attitude of the court might be changing, then we need to be able to articulate how we think that ought to change. We ought to say, no, the First Amendment doesn't mean this, it means that. And, even before Citizens United and the recent kind of deregulatory turn by the Roberts Court, it was unclear that the more moderate wing of the court had any kind of unified view of what the Constitution demanded in terms of democracy. Yes, campaign finance reform and I think democracy more generally. I mean, even before Citizens United, we were losing cases on, for example, voter identification laws, that sort of thing. And I think it talks to, we would like to be able to articulate a more unified constitutional vision of participatory democracy. I mean, we are both a law firm and a think tank, and I think that we felt the need of a deeper and more robust constitutional vision that could guide litigation strategy, that could guide advocacy strategy, and that could, act in the realm of, I guess, thought leadership would be one way of putting it. One thing that I'm pretty involved in is sort of active outreach to the legal academy, to the people who teach students, to the people who testify in Congress, write amicus briefs in litigation. And, we think of all of that as being part of the same overall effort. I mean, we don't think of it as merely generative of litigation down the road. I don't think that it was missing. I think that it had been a little bit de-emphasized. There was a big constitutional push in campaign finance around the time that McCain-Feingold was passed, and a lot of, for example, the big academic thinkers were involved in the effort at the time, a lot of the kind of constitutional heavy hitters. And then McCain-Feingold was passed, and McCain-Feingold was a deeply regulatory law. It didn't, have big romantic details. It was very complicated, and I think election law got sort of taken over a little bit by specialists. No one was articulating anymore what were the fundamental justifications for what was, this very complicated regulatory regime. And so when these attacks on McCain-Feingold started revivifying, especially culminating in Citizens United, or maybe even further down the line, there was a sense that, wait a second, how do we justify this? The Supreme Court is saying that money is speech, and that the justifications we put forward for these regulations are inadequate. What can we say on the other side? Now, Citizens United was the culmination of decades of what can be thought of as ideological warfare. I mean, there has been a very concerted effort to make money not just related to speech but equated with speech, to make corporations not just have certain particular rights but the same rights as individual participants in a democracy. And it's been part of an overall agenda that can be traced back to the early 1970s. And the lawyer who brought Citizens United has brought over 100 lawsuits testing various parts of the campaign finance regulatory universe, and Citizens United was the one in which he's gotten the most success, but it's part of a much larger campaign. I mean, part of it is corporate civil rights, part of it is about the power of, I think, money. and money to act freely without regard to regulation. And you see this in the campaign finance arena, you see this in a number of other arenas as well. I mean, you see that in some of the current rhetoric that's going on about tax, about various kinds of corporate regulation, etc. The question is, should our democracy be considered a marketplace where whoever has the most money has the most power, or is there some sort of countervailing vision of what a democracy should be?